Assalamualaikum warahmatullahi wabarakatuh and hi, my name is ALISSA MAISARAH binti SUHADI and my ID number is BDA 22110116.
Hello everyone, my name is n.amirah KHAIRANI binti KAMARSAH. My ID number is BDA 22110117.
Hello, my name is FATIN NABILAH binti ROSSLI and my ID number is BDA 22110119.
Hello everyone, my name is HAMIZAH binti HASHIM. My ID is BDA 2211020.
Siva, Chong and Mukris are partners in Ohana Enterprise with the purpose of providing interior design services. According to their partnership agreement, Mukris and Siva are responsible for contributing capital in monetary form, while Chong's contribution is limited to his skills and knowledge. They have mutually agreed that both profits and liabilities will be equally divided among them. After a few years, Siva decided to contribute more capital to the partnership. He felt that the partnership should compensate him for the extra contribution he made. However, Chong and Mukris disagree about it.
As the situation worsened, Siva stopped communicating and negotiating with Chong and Mukris. They were no longer able to achieve mutual understanding with Siva as their partner. At the same time, Siva opened a new business offering the same interior design services like Ohana Enterprise. When Chong and Mukris discover about it, they feel betrayed. They believe that in a partnership, mutual understanding is important and partners should not compete against each other. As lawyers, we need to advise Chong and Mukris for any action that they could take against Siva. And we also need to advise Chong, Mukris and Siva for any rights that are available under partnership.
To solve the conflict between Siva, Chong and Mukris, we will refer to Partnership Act 1961. There are two main points for their case, which are relationship between partners inter se and dissolution of partnership. First of all, I will explain the relationship between partners inter se. Section 26A Partnership Act 1961 tells us about partners' right to capital and profit, which provides that all partners are entitled to share equally in the capital and profits of the business and must contribute equally towards the losses, whether of capital or otherwise, sustained by the firm. Not just that, Section 32 Partnership Act 1961 tells us about partners' duty to account profit from competing business, which states that if the partner, without the consent of the other partners, carries on any business of the same nature as and competing with that of the firm, he must account for and pay over the firm all profits made by him in that business.
Next, I will explain about the dissolution of partnership. Section 37F Partnership Act 1961 tells us about dissolution by order of court, which provide whenever in any case circumstances have arisen, which in the opinion of the court render it just and equitable that the partnership be dissolved.
The issue in this case is whether Siva's contribution of extra capital should be compensated and also whether Chong and Mukris can sue Siva for involving in competing business of the same nature, which is interior design services. Refer to Section 26A Partnership Act 1961, which states that all partners are entitled to share equally in the capital and profits of the business and must contribute equally towards the losses, whether of capital or otherwise, sustained by the firm. In the case of Re-Albion Assurance Society 1880, which provides that the legal principle is that in ordinary partnership business, where there is a share of profits in certain amounts. It could thus be fairly concluded that the losses would be divided in the same proportion. Also refer to Section 32, Partnership Act 1961, that provides, if the partner, without the consent of the other partners, carries on any business of the same nature as and competing with that of the firm, he must account for and pay over the firm all profits made by him in that business. In the case of Trimble and Goldberg 1906, the defendants went to South Africa and bought on behalf of the partnership all of Holland's property, in the purpose of buying and selling for the firm's business. At the time, the defendant also bought some plots of land from Sigma Syndicate for himself and the other partner. When the plaintiff learned about this, he brought an action against the defendant, claiming the benefit of the purchase. The court held that an action by two partners was not in competition with the firm's business. Applying to the above law, the partnership does not have to compensate SIVA for the extra contribution of capital. This is because even though the contribution of capital is unequal, partners may still share profit equally. It does not have to necessarily be connected to the proportion of capital they have contributed. Aside from that, they have agreed upon the agreement to share profit and losses equally. So, SIVA does not have the right to claim for extra compensation. Also applying to the above law, Chong and Mukris can sue SIVA for involving in competing business with Ohana Enterprise. This is because SIVA is opening his own business that is of the same nature as Ohana Enterprise, without the knowledge of Chong and Mukris while he is still in the partnership with them. SIVA is obligated to disclose any profit that he earned from running a competing business of the same nature under his name, and he will be liable to pay Ohana Enterprise for all injuries and damages they suffered from SIVA running the competing business. Even though SIVA did not use partnership property, information, or opportunities for his business, he is still liable for his action of involving in competing business.
For the second issue is about dissolution of partnership. The legal issue that arises is whether the partnership between SIVA, Chong and Mukris can be dissolved or not due to their breakdown of communication. Refer to the Section 37F Partnership Act 1961 that provides whenever in any case circumstances have arisen which, in the opinion of the court, render it just and equitable that the partnership be dissolved. Just and equitable refer to a standard by which a court evaluates disputes or issues within partnership to ensure fairness and justice among the partners. It is a situation or decision that is fair and reasonable in legal decision making. It is used to determine whether it is fair and reasonable to dissolve the partnership between SIVA, Chong and Mukris based on the circumstances of their situation, which is there are complete breakdown of communication between them. Also refer to the case of Reuninergy Tobacco Co. Ltd 1961. The company had two shareholders who were also the directors. The relationship between the two became so difficult that they refused to speak to each other and had to communicate through the company secretary. As they both had equal voting power, it became impossible to pass any resolution affecting the company. The court had that under the circumstances, it was just and equitable for the company to be wound up. The state of things is such that what may be called a deadlock has been arrived at in the management of the businessmen of the company. Applying to the above law, the partnership between Siva, Chong and Mukris should be dissolved due to their breakdown of communication. The breakdown of their communication started when Siva asked for compensation for his extra contribution of capital, but Chong and Mukris refused to do so. The situation became worse when Siva opened a competing business without the knowledge of Chong and Mukris. Subsequently, Siva refused to communicate with his partners, whereas Chong and Mukris felt betrayed by Siva's action, and this lack of mutual understanding has increased frustration between them. The partnership could no longer function well as they could not work together anymore. The state of things between them has reached that and the only just and equitable situation is to dissolve the partnership. In conclusion, we hereby submit that by the provision of Section 26A Partnership Act 1961, Siva's contribution of extra capital does not have to be compensated. Moreover, by the provision of Section 32 Partnership Act 1961, Chong and Mukris can sue Siva for involving in competing business of the same nature. Thus, in the section of 37F Partnership Act 1961, the partnership between Siva, Chong and Mukris should be dissolved as there are no longer mutual understanding between them. Judging by their situation, it is the only decision that is fair and just for both parties.
As for the recommendation, firstly, clearly outline all important details related to the partnership in the partnership agreement. Partners need to outline all essential aspects in the partnership to ensure that every partner are aware of what can and cannot be done. This approach is crucial for the partnership to minimize unwanted occurrences. Furthermore, the agreement serves as a legal reference in the event of breaches, offering partners a clear point to resolve conflicts. Secondly, understand the rights and duties of partners. The members also need to fully understand the rights and duties of partners so that they do not exceed their power as partners. For example, just like what Siva has done, which is opening a competing business of the same nature as Ohana Enterprise. Thirdly, partners need to communicate properly when there is a misunderstanding. Effective communication is the essential among partners when misunderstanding arises. Without clear communication, partners may misinterpret each other's intention or expectation, which leading to confusion and conflict. Unresolved issue can build resentment among partners, which eventually leads to dissolvement of the partnership. I think that's all from us. Thank you for being here today. We are really appreciate that you guys took the time to be here and listen to our presentation.